I do all the time. Not a big deal. So we are December 1st, and we're going to talk about estate planning. Is that the best way to describe the topic? Good. I'm going to turn it over to Rob in a minute. We'll just wait for a few more people to drift in. That really annoying thing that for some reason all my things default to. Go. We don't need that. All right, so I will post this on my YouTube channel after I get the recording for it in a day or two.
I think you give everybody a link to the PowerPoint. You can send them that in case they actually want to read the words.
Yep, I can do that too. I can include the PowerPoint, and I will include your contact info in case.
That's actually on the last slide of the PowerPoint now.
Okay, good. That's very nice. In case any of you plan on dying. So if anyone dies and wants to make money, what do they need? My social security.
You basically just need your address, phone number.
I'm sorry, guys. There's an echo.
Yep, hold on. I got to mute a few people. Okay, what about Rob? Can you talk now?
Test.
Okay.
Looks
I
like
think it was just somebody had their
somebody
had their microphone on. Somebody being Shantae. Wink, wink.
that's okay. We asked people to test.
All good. Okay. All right. So what do we have here? Got 24 people.
How many more? What are you looking for? How many?
When we get to 100, we can start. What do you guys think?
How many?
No, I'd say we just give people another minute or two.
Okay.
But it's being recorded, so I guess we can get started. So this is for those of you who are not in this class normally. This is El Camino Business 117, which is personal finance. I teach a few sections of personal finance at El Camino. I actually don't teach it at Santa Monica anymore. So I just teach investments in business at Santa Monica. But I used to teach personal finance at Santa Monica as well. So I've been teaching this class for about 5 years. And I'm launching my own personal finance courses, which I will tell you guys about next week. But right now we have 25 people, a few minutes after 6. So I would like to welcome my good friend, Robert Kracht. We've been friends since the early 90s, late 80s. We went to high school together. Rob is significantly older than I am.
3 years.
Just take my word for it. If it's not obvious from the camera, just take my word for it. But Rob,
bags under the eyes. Yeah, it's legit.
Rob is we're both from San Diego. Rob is from Coronado. If any of you know where that is, it's a little, what is it? Peninsula.
Coronado Bay Bridge.
Yeah, it's a gorgeous part of town. And we went to high school together. And then, Rob, well, I'll let you introduce yourself, your whole educational background and everything like that. But obviously we've stayed in touch and stayed very good friends for several decades now. And Rob is an attorney specializing in wills, estates, trusts.
And business transactions. So I do all of that.
And so without further ado, here's Robert Kraft. If you have questions, you can pop them in the chat. I'll keep an eye on the chat box. And we're here together in the same room, so I'll just jot those down. So without further ado, here is Rob, and I will now your screen share.
All right. Hi, everybody. My name is Rob Kraft. I am an attorney. I've been an attorney since 1996. In terms of educational background, Eric said we went to high school together, St. Augustine High School in San Diego. I then went to UCSD, University of California, San Diego, graduated in 1992, and then I went to Villanova Law School on the East Coast. And graduated in 1995, took the bar, passed on the first time in 1996. I've been an attorney since then. I did not start in estate planning and business transactions. I actually started in plaintiff's litigation work and then later did defense litigation work for insurance companies. After that, I branched off into my own, and my focus is mostly on helping people avoid going to court. So that's what estate planning is about. That's what doing business transactions is about. And since this is about personal finance, The thing about estate planning is it's basically personal finance for when you're dead. So it's what happens to your stuff when you die. So that's what we're going to talk about. That's what the fancy term estate planning means. I am licensed to practice in California, so we're going to focus on California. There are differences between states. So if you or your parents have property in other states, the discussion I may be having with you today may not be relevant. In fact, we'll talk a little bit about differences between the states later on. So let's go to the next slide. So why is it important to do estate planning even when you're young? To make sure that your property goes where you want it to go. There are things, the biggest thing though for most people in California is to avoid court costs and attorney's fees. Not so much taxes. We'll talk about that later. You really have to have a huge amount of assets to have to pay any estate taxes. But the big interesting thing, and I just found an updated, back in 2017, I had found a stat that said 60% of people don't have an estate plan. And there was just a survey done on caring.com, which is, I believe, is a senior oriented website. And they said as of this year, March of this year, it is estimated that 2/3 of Americans don't have a will or other estate planning document. And so we'll talk about the types of documents that you could see in an estate plan, and one that you yourself could have right now. And we'll talk about that. You don't have to have a lot of money or even any money to have a certain type of document. You don't want to wait until it's too late. So for old guys like me and Eric, you already want to have an estate plan. Typically, and that's the issue, even if they're saying that 2/3 of people don't have estate plans, that actually includes a large percentage of people who are even over 65. And you're really risking it if you don't have an estate plan over 65. Because if you don't have an estate plan, we'll talk about what happens. And basically the state takes over. They run things in ways you may not have wanted them to run it. It doesn't mean they get the money. It just means that there are rules that states follow if you don't have an estate plan. So what is an estate plan? Well, the main one that I want to talk to you about, at least that younger people can use, is called an advanced healthcare directive. And we'll have a different slide on that, but basically that's an end of life document. If something bad happens to you, you want to have somebody make end of life decisions for you. The ones that people commonly talk about are a will. Okay, so we'll talk about that a little bit. The most important one for most California homeowners is a trust, and it's a revocable trust. We'll talk about that later. We're not going to talk too much about powers of attorney, and we're not going to talk too much about HIPAA releases, but if you saw during COVID, HIPAA comes into play with all of the mandates and various things that happen. So you may want to know about what a HIPAA release is. It basically releases your medical records. It could be to an employer, it could be to a government official, it could be to next of kin, it could be to anybody. So, but we're going to focus first on an advanced healthcare directive. And I believe that's the most important document that anybody can have, because anybody can have it. You don't have to have a lot of money. You designate a person, you call it your agent, and they make healthcare decisions for you if you're unable to make them for yourself. Well, when are you unable to make them for yourself? It's usually an incapacity. You could be hospitalized, you could be in a coma, you could just be unable to execute your medical decisions. So you have a document in advance called an advanced healthcare directive. When you hear of a thing like a living will, that's what this is. It's not an actual, it doesn't dispose of any of your property. It just means that you can decide whether and when you would withhold life support by artificial means. So one of the things people do is they say, look, if there's no reasonable chance of recovery, if I'm in what is called a vegetative state, then I don't want extreme artificial means used like ventilators and other machines, because there's no reasonable point of me recovering. However, if you're like in a medically induced coma, you may not apply that. You may, because you have a chance of recovering. So you don't want somebody to quote unquote pull the plug on your behalf. But what that does, it provides peace of mind to you and to the people you've designated, so they don't have to guess. Otherwise, in most states, they will take all actions to try to keep you alive, even if you're in a vegetative state or there's no reasonable chance of recovery. Another thing people do in these healthcare directives is they state you want to be an organ donor. You can also do that on driver's licenses, so that counts. But sometimes those, back in the day, we used to have little donor stickers on our driver's licenses. I think they've changed that now. I think they type it onto your true ID. But back in the day, they had little pink stickers that said donor. If that fell off and you didn't have it, then they wouldn't know whether you wanted to be an organ donor or not. If you don't have one of these, that doesn't mean people can't make decisions for you. The healthcare provider will generally look to your next of kin. That could be a significant other, typically a spouse. It could be your parents. It all depends on what's happening in your life at that time. But again, so for everybody in this class should probably have an advanced healthcare directive. Now, I do these as an attorney, but you don't have to get an attorney to do them. They do offer blank advanced healthcare directives at hospitals. They are form documents, so you fill them out handwritten, and typically you have to have either a notary or 2 witnesses to it. And the witnesses, if you're in a hospital and you do this, you typically get people, nurses or people who are there who aren't your agent to sign off on it. If you have an attorney do it, what?
That means not your agent.
Okay, so let's say I take my wife as my agent. She can't sign as a witness to the healthcare directive. It would have to be somebody else. So it could be my brother, or it could be 2 nurses, as long as they can identify me, as long as they know that I am who I say I am. Go ahead.
So sorry, agent in this case means, let me go.
Agent in this case means the person who makes the healthcare decisions for you.
Okay, so that person cannot be the one.
That person
witnessing the
cannot witness the
document
document. That also applies to other documents like wills.
Okay.
So there's 2 ways in California to get these documents verified, because there's always a concern that somebody at the end of their life, you see this in movies all the time, where people sign over their estate on their deathbed to somebody who tries to steal all their money. And to how you protect against that is you have either be notarized by a notary public, or you have 2 witnesses, 2 uninterested witnesses. And that means they're not your agent. They're not your benefit. If it's a will, they're not your beneficiary.
But could
So
they be related to the agent?
they can be related to the agent. So that's not a requirement that they not be related to the agent. So you still can't completely avoid the potential for what they call undue influence or coercion. You just do the best you can to try to avoid going to court over these things. Typically, people don't contest advanced healthcare directives, although there have been some famous cases involving people who wanted to starve themselves to death. They made it all the way to the Supreme Court. And that's why people are now focusing on people deciding ahead of time what they're going to do. A will. So that's what you mostly hear about when you talk about estate planning. It's not the most important one in California, but it is useful to direct what happens with your assets. And it's only a certain type of assets. It's your probate assets. So we'll talk a little bit later about what is in probate and what's not in probate. So one example, if you haven't put your house in a trust and you own your house, then your house would be a probate asset. However, if you have a life insurance policy and that has a beneficiary, that's not a probate asset. If you have a bank account that has no beneficiary, that's a probate asset. If you have a bank account that has a payable on death designation to somebody or something, that's not a probate asset. So you have to decide what is a probate asset and what is not a probate asset. And what people do typically is they create a schedule of their assets and they attach it to their will. The person who runs your will is called an executor. Okay, that's basically the same thing as an agent, but it's just called an executor. First, they have to pay your debts and taxes. They administer the estate, and then they distribute assets to the people you identify. In a will, you identify who your beneficiaries are. So that's one benefit of having a will. You decide where your stuff goes. If you, what?
The executor paid.
Okay, the executor can be paid. We'll talk about that later. I have a separate slide devoted to how executors are paid in California, and it's the thing you try to avoid. But you can be, if it goes to court, they get a statutory percentage. If it doesn't go to court, the executor can pay themselves. So typically, though, in families, the executor doesn't pay themselves. Typically, that doesn't mean it doesn't happen, but there are limits on what they can pay themselves. If they incur costs like mailing costs or if they have to hire an accountant, those are legitimate expenses of administering the state, and that comes out before money goes to the beneficiaries. You can also use a will if you have minor kids, so it can designate a guardian. So you hear about people wanting to disinherit people from time to time. That's tricky. Typically, the state of California doesn't like when you disinherit people, so they scrutinize that more rigorously. So if you do want to disinherit somebody, it's a good idea to state the facts in the will and state who's being disinherited and why, and that helps avoid litigation over the will later. So one of the biggest reasons people get a will is they have kids. Typically, that's when you start thinking about the future. If it doesn't come to you then, it may never come to you until it's too late, but that's one of the biggest reasons why people get a will done. But sometimes, like I said, a will is not enough, and that's where we're going to talk about trusts. The big thing about trust is you're trying to avoid all of the costs, and those costs sometimes will include court costs, the payment of an executor, or they'll include attorney's fees. So that's what, if you own a home in California, you're going to want to get at least a revocable trust. And the thing about a revocable trust, the key word is revocable. You can change it, you can revoke it, you can get rid of it. It operates like a will in that regard, but what happens is you actually take the title of, let's say it's a house. Typically the house is in your name, or it's in your name and your spouse's name, and you take it out, the title out of your names, and you put it in the name of the trust. So when you put a house in a trust, it is no longer in your probate estate. So that's what you're avoiding. You're avoiding probate by putting your house in the trust. That's why you do a trust. And we'll talk later about the costs that you avoid. Yes, what we're going to talk about what probate is a court process after you die, if you have to do it. And you try to avoid that by getting as many assets as you have out of your probate estate. And the biggest way in California to do that is through a trust, typically a revocable or living trust. There is a thing on here about taxes, but for most people in California, estate taxes don't come into play, and I'll show you why in a later slide. There's another type of trust too, called an irrevocable trust. And the key word there is irrevocable. You can't amend it once you do it. There's a reason why people do this. The biggest reason in California is Medi-Cal. So if you're nearing the end of your life and you want to avoid Medi-Cal putting a lien on your property, you typically want to have your property in an irrevocable trust. However, California has what they call a clawback or a look back period. So if you try to do this at the last minute, it won't work. In California, it's 30 months. In other states, it's 5 years. So it depends upon what state you're in. So let's say you think that in 10 years, you're going to end up having to spend all of your money on medical expenses. If you take your house and put it in an irrevocable trust, 10 years before you have these expenses, it's not part of your estate, and Medi-Cal can't put a lien on the house to pay for the services they provide you. If you try to do it within the 30 months period, then they void your trust, at least as far as the number of months that you haven't sustained the 30-month period. So if you did it 2 years in advance, you'll probably have to pay 6 months. They'd probably be able to do a 6-month lien of services against your house. So Medi-Cal tries to recover the costs because typically indigent people don't have any money to pay back Medi-Cal, and they're allowed to do a lien against your estate. So if you put it in an irrevocable trust, you avoid Medi-Cal doing a lien against your estate. If you put it in a revocable trust, Medi-Cal can come back with a lien against you. So you can also use it. It changes asset values for other things. Most people in California don't end up doing an irrevocable trust. There are other things you can do in your personal finance that aren't like an attorney's job. There's long-term healthcare insurance. There's other types of insurance. There's annuities. There's various things, various vehicles people use. But in terms of legal things to avoid Medi-Cal taking your house, it's an irrevocable trust that you would use. It's not that common in California because people typically have other assets. And typically when people end up in like long-term care, especially in the sad fact is you don't end up in long-term care very long. You're not there for 10 years. You're not there for 5 years. You're there for a few months. And usually people who go into hospice pass away very quickly. It's just the nature of our healthcare system. But if you are ever concerned about, if you had some sort of congenital condition that you know in X number of years, you're going to have huge medical expenses, you may want to talk to an attorney about an irrevocable trust if you own a house or have other investment assets in California.
Is it all investment?
Well, it's anything that you have, any asset you have can be attached by Medi-Cal if you don't have it in an irrevocable trust. But irrevocable trust, like I said, can't be amended except in there's very rare circumstances. Like if you can prove that somebody fraudulently got you to do it, or tried to do a deathbed, but even here it doesn't apply to deathbed. If somebody lied to you and you could go to court and prove that, you can get out of an irrevocable trust, but it's limited. It's hard to break in California. So you have to, if you're going to do an irrevocable trust, you have to do it right. And you usually only get one shot at it. That's why most people do revocable trusts in California. People want control over their property. That's the thing. Once you do an irrevocable trust, you basically lose the ability to dispose of the property. The trustee gets to dispose it. And if you do various shenanigans with it to try to pay yourself an income from it, then the state won't recognize it as an irrevocable trust. So there's all sorts of things, all sorts of restrictions beyond a half-hour presentation that I can't go into, like talk to you about all of that. But the big thing is in California, most people use revocable trusts. Here's another thing that is actually recent, since the last time I did this class, something called Prop 19 passed in 2020. Now this is a tax thing. I'm not a tax attorney, so you're going to want to consult with a tax attorney. But basically what happened in 1978, there was this thing called Prop 13. And it limited how much your house was valued for property taxes. So what it was designed to do is to allow older Californians to keep their houses, because it limited how much you could increase their tax burden by 2% a year. So if you had a $100,000 house in 1978, in 1979, they could only tax you on $102,000, even if the property was worth $500,000. Another benefit of Prop 13 was called the parent-child exclusion. So if you passed your property on to your kids, they could keep the property and keep the value of the house as the assessed value of the house, not the real value. So if your parents had their house for 40 years and they were only paying, so I gave an example here. If you bought a house in 1980 at 100,000 and it's worth 2 million now, and that's not far from the truth for many people in California. I know people who bought their houses in the 50s for 25,000, their house is worth 3 million now. If you bought it in 1980, your property tax is based on $100,000, because that's what you bought it for, plus a 2% base increase every year. So if you go out 40 years, you may be getting taxed on 100 and well, it's not, it's under $200,000, I think. But we can figure it out. Yeah, go ahead. You can do that.
Go ahead, we keep talking.
So the problem with Prop 19 is it changed all that. So now, if you want to pass your tax on, your house on to your kids, the person actually has to live in the house. And it can only be one kid in order to keep that tax basis. Otherwise, they reassess the property at its fair market value. So instead of paying tax on $200,000 of assessed value, you end up paying tax on $2 million.
What's the growth rate for property taxes?
It's 2%.
2% max?
Yeah.
Okay.
2% max. So he's gonna run a little formula on it. We'll get you that later.
It's 1.125%.
Mhm.
So we're setting 1980 as
Yeah.
the price?
Yep.
And for those of you here, I'll switch the screen sharing so you guys can see.
I guess I could have done that, but I was told there'd be no math in this.
Wait, what did you study in undergrad?
Oh, undergrad, I did start out in math.
Yeah, okay, so you have a math degree.
I do,
But you were told.
okay, but
there'd
I
be no
just
math.
didn't.
Okay.
All right.
Interesting. Interesting. Okay, so this is the growth rate of the value of the property. We're going to say 5% from 1980.
Mhm.
Oops. Go.
Oh, you're gonna find out what the fair market value is?
Yeah, so it's
Okay.
way more than that.
So,
But
yeah,
this number,
Mhm.
1.125%.
but it's only on the assessed value, which can only go up 2% a year.
Right,
So it can
so
only go-
this goes,
Yeah,
basically the tax can go up 2% a year.
the tax can only go up 2%, and it only, well, no, the base, your assessment can go only 2 up. So if your house is
It's the same-
assessed
it's the same
is
thing.
100,000, true, but isn't it 1%? Isn't property tax 1%?
1.125%.
Oh, 1/8, okay.
Yeah.
So,
Okay, so basically the home was worth 100,000 in 1980.
yep,
The tax, which is, we will
1/8.
pay 1.125% of home price sets the tax base.
Yep.
And those of you in my investments class, we've done this a few times. This number, the actual tax, that taxable amount is set here in 1980, or when someone purchases the home.
Yes, it's set, yeah, it's set when you purchase a home.
So if we set it to 100,000 in 1980, your tax is 11.25 a year. That 11.25 a year can go up max 2% per year.
And it always does. That's the state of California. They will increase it 2%.
And so we'll hide these middle years here because we don't need to see those. And what do we say the property is worth now?
You said it was worth 776,000.
Well, no, but at the example you're giving.
Oh,
So-
2 million.
So a house that's worth, we'll
Yeah,
call it-
that's good. That's good enough.
we'll call it, say, a house that's worth 1.7 million, your tax has only doubled in 40 something years, even though the home is worth 17 times more.
Yeah, so it's a huge property tax benefit. But Proposition 19 has changed that.
Now, just let me interrupt you 1 second, Rob.
Sure.
If someone new buys the home and pays the market price,
They're paying like 20,000 in taxes.
they're paying $20,000 now in taxes. If you keep this,
Yep.
you're only paying 2,500, but a new buyer. So if you go like in Santa Monica, a lot of these old homes are being sold that people have owned for 50 or something years. The whatever government gets the tax, who gets it? The county?
County, but then they turn it over. It's a complicated process. They go to the county, it goes to the state, and then it comes back to the county. A portion of it does.
Makes
I'm
a
not
lot
a
of
tax
sense.
attorney, but that's what I was told happens.
So it's basically got to cycle through 15 different layers of government to go back to where it started. Okay, that makes sense. And long and short of it, they love this. Obviously, they love new transactions because now, look at this, they're getting an extra, they, being the government, is getting an extra $18,000 a year.
So before Prop
I'm
19,
sure
they
they'll
loved,
use it wisely.
so before Prop 19, they loved transactions to non-children. So if you sold it to a third party, then the house gets reassessed and you pay that 20,000 property tax. What Prop 19 does is limits the ability to use the parent-child exclusion to keep that $2,600 tax and shoot it up to 20,800, except when the beneficiary uses that home as their primary residence, and they have 1 year to do it.
Oh, that's it?
Yes, they have 1 year to establish it as their private residence. So now, I don't think this is sustainable. I think eventually they're going to have to, pass a different law, pass another proposition reversing this. But we're in the state of California. You can't predict what they're going to do. What this does create is a massive windfall in property tax revenue to counties and states. And typically, once a government gets a hold of revenue, they don't want to let it go. So what there could be is a future Prop 13. So Prop 13 was during a tax revolt in the 70s. I was only 8 years old, so I don't know anything about it. I just know there was a thing called the Howard Jarvis Taxpayers Association, and they got this limitation on property tax rates. And everybody loved it until Prop 19 came in. There was arguments as to whether Prop 19 was fairly described in the ballot initiative, but regardless, it won. So that's the law now. The law now is you have 1 year as a beneficiary to use the inherited home as your primary residence. That makes it really hard on, like, for example, I have 5 brothers and sisters. So we won't be able to use that because you're not going to put 5 families in one house.
Do you all, but you don't all have to use it, all the kids.
Yeah, because each person is a benefit. You'd have to, in order for it not to apply, my parents would have to have a big enough estate that one person could take the house and the others would get other property. So that one person, so it would have to be one beneficiary or the people living in the house. It makes it very hard to keep a house and keep the low property tax rate. So what they believe is going to happen is you're going to see a lot more sales before people pass away. You're going to see far fewer families stay in homes. You're going to see, it actually could end up in a reduction of property values because there's going to be, allegedly this would lead to a greater supply of property on the market as you have to sell it because some people can't afford the property tax rates or they'd have to turn it into rental property. So there's all sorts of unknown economic issues with this. But it is important to know because it's changed everything in California in terms of getting a house through probate or through a trust and keeping the property tax rate the same. It's just something you're going to have to deal with. But go ahead.
This was on the ballot.
It was passed in November 2020. It went into effect in February of 2021. So there was a mad scramble between November of 2020 and February of 2021
to die.
to use, to not die, but to use all sorts of devices. And I'm not going over them today, but they're complicated. Intentionally defective grantor trusts is one of the things people use to avoid this, but you can't use them anymore. So right now, it's just something to know that when you pass, even if you put your property into a trust, there's a good chance that the property tax will be reassessed and be a substantial increase. Depending upon how long the house was owned by the prior owner. Obviously, if people bought in the last 10 years, the increase has been substantial, but nowhere near what it's been if it was 20, 30, 40, or 50 years. But that's a tax question. You're going to want to consult with a tax attorney on that. It's just something that, I'm out of the, I guess I'm out of, I just need to get back to clicking into slides. Okay, down, all right. All right, so, okay, we're good. Okay, there's some questions. The best time to decide, we can go over some questions right now. The best time to decide when to create a trust. So one of the slides we're going to talk about is that there is a thing in California called a small estate exemption. It's up to $184,000. So if there are assets, gross assets, not net, gross. If you have gross assets of less than $184,000, you don't have to go to probate. So you don't really need a trust. You typically want to get a trust as soon as you own a house, because probate is determined on gross assets, not net. Like net, you may have a $2 million house, but you may have a $1.5 million mortgage, and you may only have $500,000 of equity. But probate is determined on gross. That's just before you ignore the debts. Yeah. Any mortgages, any liabilities. Yep. Okay. So can I stay in my boyfriend's property until I pass away? If you're in a boyfriend's property, that creates separate issues. You'd have to be listed in his family trust. If you stay, okay, until you pass, okay, it depends upon who survives. Okay, if you out-survive the boyfriend and you're listed in the trust, then yes, you can pay the same taxes. But if you're not listed in the trust, then you won't get the same benefits. So in fact, the trust may have, if the trust has different beneficiaries, you may end up out of the house. It's just,
I think they could boot her out.
yeah, because typically boyfriends, significant others don't have the same rights as spouses. It doesn't matter whether it's same-sex or traditional.
What to do with common law?
There's common law stuff involved, but it typically doesn't help in estate planning, because we'll talk later about how the state views it usually deals with, you're dealing with parents, siblings, kids are the primary beneficiaries. But we'll have a separate, it's called when you die without a trust or a will. Can I pay taxes for his prices? It depends. Oh yeah, well, that's the same question. It depends upon if you're in the trust, if he's on the trust. I'd have to see the trust document and see who's on the name of the deed. That's important.
Ryan's question.
No, the property's value and tax base does not get reassessed when it's transferred to a trust. That's a great question. In fact, there is something you have to watch for though. And this is when you're dealing with banks. When you put a property into a trust and you had it in your name, let's say Joe and Mary Smith get married. They own property. They want to create the Smith Family Trust. If they took the property as Joe and Mary Smith and they took a mortgage with Chase Bank in the name of Joe and Mary Smith, and then they transfer the property to the Smith Trust, if they want to refinance the house, some banks make them take the property back out of the trust, put it back into Joe and Mary Smith's name because that's who their loan is with. Okay. Now, some banks don't make you do that, but some banks do. And then you have to pay attention, because once the refinancing is done, the house is no longer in the trust. So you have to transfer it back into the trust. So just be aware that if a bank asks you to take something back out of the trust for refinancing a house, if you want it to go back into the trust, you have to retransfer it back into the trust. That does not change your tax basis. It's just something to be aware of. There is no common law in California, but there's a good question from Holly. California is is a common law state. I mean, all states except for Louisiana are technically called common law states. So if there isn't laws on the books, then what we call the common law is usually case law that was decided years ago that will govern situations. But in California, we have a thing called intestacy, which I'll talk about in a future slide, that talks about what happens if you don't have a will or a trust.
Is there a pill for that?
What?
Is there a pill for that?
Is there? Yeah, okay. I know it sounds like you need a pill for that, but that's not true. Do I need an attorney to process a trust? Technically, no. You can do all these. You can find examples of all these documents on LegalZoom. and other services. But I wouldn't be a good attorney if I didn't say it really helps to have an attorney shepherd you through the process, because a lot of the things that are come through LegalZoom may work for very simple things, but they are all cookie cutter. So you're going to be asked to fill in some blanks, but you may not be able to edit certain language. So you got to be careful when you use things like that. Could you get away with doing a LegalZoom trust if you just own a house in California and you have no other assets? Technically, yes, but you better make sure you do it right. So
What alternatively, what's the cost for something like yours?
oh, so my cost range, it actually depends. It always depends upon the complexity. Typically for a house in California, I charge between $1,500 and $2,000 for a trust, and I'll explain why later. There are various things involved, so that's just for the documents. I also do a thing called full service, where I will prepare the deeds for you. I will get them recorded. I will shepherd you through the process of contacting your banks and everybody else you have to contact to get everything titled properly. That has an extra charge. We will go through why I charge what I charge, because it's basically because of what we save you in the future. And also the amount of work done on a trust is more work than's done on a will. So go ahead.
I just wanted to jump in and say that Rob and I were talking about this quite a while ago, and I had Rob do my trust
Yes.
about 5 years ago. And I didn't do the full service thing, and what ended up I don't think my trust is still done.
No, his trust is not funded. So here's okay.
Because I didn't do the full service.
Let's back up a little bit.
I'm not going to go to the county office and do all that stuff. So
Let's back up just a little bit. We'll make it really simple. You have a house, you want to put it into a trust. You hire me to do your trust for you. I give you the documents, you take your trust to your notary public, you get it notarized, your trust is valid.
Which is like at a US
You can go to a bank,
or-
you can go to AAA. AAA does notary stuff for $5, I think, if you're a AAA member. There's various UPS.
It's very easy.
It's easy to get you can get a mobile notary public. Prices range. It just, let's say $5 to $50 is a range. You do all that, your trust is valid. You don't take the deed from your property and retitle the deed. You don't prepare a new deed, and you don't record that deed with the county. So your trust doesn't have anything in it. It isn't funded. You've just spent money and do not have a funded trust, do not have an actual trust that you can use. I mean, you can once you retitle, as long as you have a trust, you can retitle things. Eric's circumstances have changed, so he couldn't use that trust. He's going to have to do another one if he wants one. But that's a different. Do we have any more chat stuff, or is that? I want to see if I can get more questions. I think that's it. I think we're down. I think we got to Guadalupe's question.
Okay.
Is there more? Okay.
No, go ahead.
Keep them coming. I'm glad to hear these questions. Let's briefly talk about a power of attorney. That's similar to what we talked about before with the Advanced Healthcare Directive. However, what this one does, and even though they call you an attorney, you don't have to be an attorney to be the agent. You're a designated person. You act on behalf of another, and you can do acts while they are still capable of doing their own. So that's what a power of attorney can do. That's called a durable power of attorney. There's multiple types, but typically people have two types. One is for financial and one is for medical. I know I put a slide in there that says you can do one for legal, but typically financial is bundled in with legal. So there's two types of power, two powers of attorney, one for financial, one for medical. The difference between a medical power of attorney and an advanced healthcare directive is that a medical power of attorney applies as soon as it's signed. If it's a durable one, so there's two types. There's a durable one that automatically happens. Your agent could act on your behalf right away. Your agent typically doesn't. Usually while you're still alive and capable of making your own decisions, the agent doesn't make decisions before you, but they can legally. That's called a durable power of attorney. It springs right into effect as soon as it's notarized. There's one called a springing power of attorney that can spring into effect when you're even temporarily incapacitated. And one of the circumstances, and here's the example. You and your spouse go on a climbing adventure in the Alps, and you're lost in the Alps for 7 days. So people at home think you're dead, but you're not, okay? But you may be viewed as incapacitated. And if you have a financial power of attorney, your son or your other agent or your daughter or whoever could pay your bills while you're being located in the Alps. So it's not just an end of life thing, but it's also any incapacity or disability. And typically it's things where people are either under anesthesia, or if something happens, or if they're like a lost in the Alps situation. It does help for people who are older. So when people are older, you've heard of things like Alzheimer's and dementia. So if you have one and you end up having Alzheimer's or dementia, your agent can make medical or financial decisions for you without having to go to court to get a guardianship or a conservatorship. So there's various situations where a power of attorney would apply that an advanced healthcare directive wouldn't, because early onset, early Alzheimer's and early dementia isn't an end of life situation. People are still lucid at points and still can make decisions for themselves, but at other times they can't. So they slip in and out of ability to make decisions. So you have a power of attorney that covers for that. That's not what an advanced healthcare directive could do. An advanced healthcare directive could apply at the end stages of Alzheimer's or dementia, where you're on a feeding tube or whatever the bad situation is. But I always caution clients about powers of attorney because they're super powerful. They allow people to take actions on your behalf whilst you are still able to take those actions, unless you create a springing power of attorney. So when people say, oh, I do want a power of attorney, I try to guide them towards a springing one, not a durable one, unless they're a relatively advanced age. Just because everybody wants to make their own decisions for themselves typically. The HIPAA release, we'll just talk about it really briefly. It basically allows doctors and healthcare providers to give your information to your agents, who are usually family members. And by agents, I mean, it could be the power of attorney agent. It could be the executive of your will. It could be the trustee of your trust. So your agent in a trust is called a trustee. Your agent for a will is called an executor. Your agent for an advanced healthcare directive is called an agent. They all have the same role. They all act on your behalf. They're just called different things. So a HIPAA release, you have privacy in your medical records. And at hospitals, they may ask you to sign one, and it allows them to provide information to family members. Whereas if, like during COVID, people weren't allowed to visit you in the hospital, at least early on. And then later on, they had restrictions on who could visit you in the hospital. So if your agent wasn't in town, let's say for some reason your agent on a medical power of attorney was your sister, and then you get married, but you don't change your power of attorney, so your sister's still your agent, and your spouse is in town with you, and your sister lives in Missouri. If you end up in the hospital during COVID and you're only allowed one visitor, and your agent isn't in town, they can't visit you, and your spouse can't get your medical records easily. They still can. You could do phone, you'd have to do all sorts of stuff, calling people in Missouri, have them sign affidavits, fax them back to the hospitals, but it just takes a lot of process. So a HIPAA release will allow things to move quickly to family members, spouses, if they're not designated as agents. It's typically family members though. All right, now we've already talked about this a little bit, but this is probate property. What does it mean? And Eric has put in the thing about gross, because that matters. Oh yes, Okay, Brian, good question. Can you have multiple of each type of agent? Yes. I don't recommend it to have multiple on the same line, but typically in a document, you have an agent and you have a substitute agent. So if the agent no longer wants to do it or they pass away after you've done the document, your substitute agent comes in. I typically ask people to give 3 names: their agent, a first successor, and a second successor. So yes, you can have multiple types of each agent. You typically don't want to have, let's say, 3 agents, or you definitely don't want to have 2, because if they disagree, then you don't have a majority decide. If you could have 3, but you don't want people fighting over this type of stuff. So it's usually better to just have 1 agent on each line. It does not have to be the same person in every document. In fact, in many families, they don't want it to be the same person on each document because people feel overwhelmed by the responsibility. And just because you designate somebody your agent doesn't mean they want to be your agent. So typically you'll have a different agent for each document. If you can. If you can't, totally understandable. They'll be your agent for everything. But going back to probate property. So it's any assets in your name. That includes your bank accounts, real estate, cash. Now, when it's bank accounts that don't have a designation. Most people's bank accounts don't. Cash, securities, personal property. That's like hard stuff, like this table I'm sitting at, the chair, the picture, anything, furniture, jewelry, books, anything that's valuable. If you have a retirement account that's payable to your estate, that's probate property. Typically, people don't have retirement accounts payable to the estate. They have retirement accounts payable to a significant other or child. That isn't property of the estate. Life insurance typically is not probate property, but it is if it's payable to the estate. So if you get life insurance, don't make it payable to your estate. You want as little probate property as possible. That's what trusts are for. They take your real estate out of the probate estate. You want to put called transfer on death or payable on death designations on your bank accounts. That takes it out of the estate. You want to put you want to retitle your securities into your trust. That takes it out of the probate estate. With personal property, it's harder, but you can do a generic thing and put that in your trust as well. What are non-probate property? Any jointly owned assets. Okay. If you get sued and your only asset is your house, if they win, can they get to your house? If the house is in a revocable trust, yes. Okay. They can. If it's in a revocable trust. If it's in an irrevocable trust, as long as you followed all of the rules, probably not. Okay. Because an irrevocable trust, you don't have the power to dispose of. So that's a very good question. That's not why you don't do probate to avoid lawsuits for, let's say, being sued for like a car crash or being sued for a business a typical litigation. Probate is designed to avoid probate court, not other courts where you get sued for breaching a contract or injuring someone. That's a different thing, and you use different types of asset planning mechanisms like irrevocable trusts, and some people use offshore assets. I don't do those, so I can't talk about offshore assets and how you structure those. Sorry. All right. Going back to non-probate property, anything that's jointly owned is not your probate property, because if it's jointly owned, when you die, joint ownership transfers to the person who is alive automatically. If there's only one person left, then it becomes their probate property. Okay. But while it's jointly owned, it's not probate property. We talked about if you have a beneficiary designation. So that's on life insurance. That's on bank accounts where you create a TOD or a POD. So that's not part of your probate property. And any assets held in a trust are not part of your probate property. So you want to avoid probate property, so you try to get everything out of your probate property. And here's why: you want to avoid the probate process. The state is trying to make sure your assets are distributed to the appropriate individuals. So they will require you, if you don't have a trust or you don't have, you have a large enough estate, they will require you to submit a will to the probate court. And the probate court opens up a case and they do things called letters of administration. And they have control over your assets until they're distributed. You can avoid that. We talked about a declaration of a small estate. So in California, that's gross assets of 184,500 or less. That's an increase. So last year it was 166,500. Can't promise it's going to increase, but it has been increasing every year, at least for the last few years. Probate courts do not have any control over joint assets that we talked about, over life insurance and retirement accounts with beneficiaries, over any property in a trust, over any bank account that has a transfer on death or payable on death designation. Probate courts only have jurisdiction over probate assets. Here's the other important thing. People talk about taxes all the time. Probate has nothing to do with estate taxes. We'll talk about that later. Most people do not pay estate taxes today, and we'll talk about why later. Here's the biggest reason why you want to avoid probate in court, because of these statutory percentages. It's all on the gross value of the probate estate. So each of these percentages apply. That the percentage gradually gets lower as the amount happens. But these are presumed fees. So your administrator can claim them in probate court as a presumed fee. They could always argue for more. They could always ask for less. They'd have to prove they're entitled to more. They could always ask for less. But not only does the administrator get the money, but also any attorney they hire gets the money. So it's a double dip. And for an example, and I do use this as the bottom, if you had a $2 million gross estate in California, the statutory fees for the attorney and the executor or the administrator would total $66,000. And that's what you're trying to avoid by getting a trust. You pay $1,500 to $2,000 now for a trust, as opposed to your beneficiaries paying $66,000 later to an attorney or the administrator. So that's a common cost if you end up in probate. Oh, okay, we're getting
So
some
if you
more.
had a $2 million house
Well, $2 million gross estate, I said.
and a 1.9 million mortgage,
You're still paying $66,000 because the mortgage is just the that leaves, it's a gross estate. Now, is an administrator always going to request that? Is an attorney always going to request that? No, but you have no control over it after you're dead. Yep, that's what would happen. Typically, though, if you have a $2 million house and $1.9 million mortgage, hopefully you put your house in a trust so that you have a zero estate. And in that case, you could have an attorney, or you could find one yourself, prepare a small estate declaration. You don't even have to file it with the court. You just have to have it ready in case anybody asks. If any creditor, let's say you owe $10,000 in credit cards, and you have a $2 million house, $1.9 million mortgage, $100,000 in bank accounts. A creditor comes and says you owe $10,000. You pay them, but you show them a declaration saying, we don't have to go to probate over this. I'll write you a check for the $10,000 out of this $100,000 account. There's still $90,000 to pay for anything else, and also to distribute to beneficiaries. The house can go to the beneficiaries listed in the trust or in the will. Actually, in the trust. If it's a will, it goes to probate. That's why you need a trust, to avoid probate. If you do only have a will, then your gross estate needs to be below the statutory minimum. And right now that's $184,500. That's gross, not net. So in Eric's situation where he sent that note, your net estate is only $100,000, but that isn't what's counted for purposes of probate.
Any idea why that is?
It's just the way the situation, that's just the state's rules. They do, so that percentage is actually limiting. Attorneys love to charge a lot of money. If attorneys could, they charge way more than that 4%, 3%, 2%, 1%. Attorneys would charge hourly rates. They charge a contingency. They charge like 20% of whatever. So attorneys would charge more if they could. So that's actually the state trying to limit the amount that people can take on a routine estate. Now we talked about if you don't have a will, okay? So a basic question is, what is that called? It's called intestacy, but it just means you die without a will. If you die without a will, can you disinherit someone? The answer is no, you can't. You have to have a will or a trust to disinherit someone. So even if you're mad at your son, you can't kick him out of the will. You can't take away any money from him, because that isn't how intestacy works, as long as you don't have a will or you don't have a trust. So basically, that's why you want to avoid intestacy if you want to, but also intestacy goes through the probate process. So that's another thing. So all those costs that I just talked about, if you have a will or don't have a will, intestacy goes through the probate process. Then the court will appoint an administrator. In a will, you've determined who the administrator is. The court will appoint an administrator. It could be an heir, it may not be. And then the administrator appoints an attorney. So what happens if you don't have a will in California? If you're married, basically the spouse gets all of it. If you're not married but you have children, the children get equal shares. If there's no spouse and no children, the parents get all of it. No spouse, no children, no parents, grandparents get all of it. So cousins don't count. Cousins don't get anything in intestacy. Nephews, nieces, nobody gets any, nobody, it's only spouse, children, parents, or grandparents. If you don't have any heirs, the state of California gets it. Girlfriend does not get it. Girlfriend does not get it in intestacy. Boyfriend, girlfriend does not get it if you die without a will. So if you want to give money to your boyfriend or girlfriend, or anybody you want, a charity, anything, you better have a will or a trust. Okay. Or else you're going to end up giving it to your children, your parents, your siblings. So if you have or your parents. So siblings count as heirs. I didn't include that on the slide. The slide could be pretty long, but you want to avoid, so the state of California getting it is rare. That rarely happens. So that's just the last step. If they can't find any heirs. Does they have mattered if they live with each other for years, but are not married and have kids? It could. I haven't dealt with common law situations in terms of, so because they have kids, my guess is the kids would get it. I'm not sure if the common law spouse does. I can actually look that up and I'll get back to Eric on that. I haven't dealt with that situation where a common law or what somebody would try to be considered a common law, but Marisol, I'll definitely look that up and get an answer to Eric. Let's look up common law. I'll make a note for me to look up common law spouses.
So I'm going to give Rob a homework assignment.
Yeah, I'll do that. I can't promise I'll do that tonight or tomorrow.
So what am I looking?
We're looking for common law spouse.
Yeah.
Intestacy rights.
Intestacy.
Intestacy rights, because typically, if you have a will, you're going to name your common law spouse. And I'll look it up as well if a will situation. But also they have kids. Make sure that's important. That's an important thing. So that's why you don't want to die without a will. Typically, you don't want the state to get involved. So now let's talk about taxes and why, for most people, it's not an issue. Estate taxes. This is taxes. Siblings. So siblings are included, Guadalupe. They're in the scheme. If you don't have a spouse, you don't have kids, and your parents are all dead, I think your siblings come next. Okay, they're fourth in line in intestacy if you don't have a will. Okay, But cousins, nieces, nephews are not in that scheme. Okay, why don't you have to pay an estate tax? Typically, because there is a thing called a federal estate tax exemption, and it is super high. Okay. Right now, and this is increased, and you'll see, right now it's 12.06 million for a single person, 24.12 million for married. So there aren't many people, there's a fair amount in Silicon Valley and the like that have this. So they have to do different things to lower their federal estate tax burden. This exemption is scheduled to go up another 860,000 next year. It used to be a big deal. Back when I first started doing this in 2000, the exemption was $675,000. That was it. So there were different types of tax planning you'd have to do to make sure that people didn't owe estate taxes. But by 2017, it was already 5.5 million. There was actually 1 year where if you died, no matter how much money you had, you paid no estate taxes. There was a 1 year holiday. I don't have that year. I just don't.
Who was it? Who got?
I might have been Warren Buffett.
Oh.
No, who was it?
He's still alive.
Oh, okay.
George Steinbrenner.
Oh, George Steinbrenner got, okay. So the former owner of the Yankees was immensely wealthy, but he also had more things like horses and other
He
property.
was worth like $1 billion.
Yeah, he was worth a ton. He had a ton of property in Florida, but also the Yankees are worth a ton. And he died during the year of the estate tax holiday. So his estate paid 0 federal taxes. California does not have an estate tax. So you don't have to right now. I mean, that could always change. You never know what a legislature is going to do. New York does have a state tax. So it depends upon what state you're in, whether you have to pay taxes or not. New York has a different exemption level than the federal government. They have a lower exemption level. But that's just an example. But in California, you don't have to pay any estate tax. If you did have to pay estate tax, it's currently 40%, which is a high number, but it used to be higher. I believe it used to be 65%. And that was back when the exemption was only $675,000. So you could see huge estate tax bills, but people did all sorts of things with trusts, with offshore accounts, with all sorts of mechanisms. There was a huge industry in tax avoidance. So they decided to limit that industry by just making the exemption large. And it stayed large. That doesn't mean it's going to stay large forever. It's always possible that Congress could change this and take it back down to what it was before. But right now, estate tax is not a reason why you need to do estate planning for almost everybody in California. It's because the exemption level is so high. But like I said, the government can change its mind, and people like Bernie Sanders and others do want to see the estate tax exemption lower because they believe that the rich aren't paying their fair share. So they have to have them pay. They want them to pay more, and one way to get people to pay more is through the estate tax. Gift tax. That's a small thing because it works in conjunction with the estate tax exemption. So basically, if you give a $15,000 gift every year to somebody, that's exempt from estate tax. If you give more than that, you can use your a portion of your estate tax exemption so that you don't have to pay gift taxes. So typically, people will apply any gifts they pay to avoid the gift tax. They'll pare down their estate tax exemption. Certain gifts don't get taxed at all. It's tuition and medical expenses of a child, but you have to pay the school and medical provider directly. Gift tax is typically not an issue for most people in California. And it's because of the massive estate tax exemption, which you can apply if you were fortunate enough to give more than $30,000 to Santa Monica College or to Eric Senko. So in summary,
I'm gonna shoot me a message if they need my address.
oh yeah, so Eric has said to send him a DM if you need his contact information. In summary, if you're young and you don't have kids and you don't have property, but you do have bank accounts, I recommend you do at least three things. Get an advanced healthcare directive, get a will, because you don't have property yet, and make sure all of your accounts have a payable on death designation. So those are the three things. You're going to get a copy of this PowerPoint. If you wanted to skip to the end for what you should do, that's what I recommend everybody in California do. Do you have to do it? No, because there are things that could happen in California, like intestacy, or for an advanced healthcare directive, your parents could make the decision for you. There are things that could happen but things will be more smooth if you have all of these things. It typically doesn't cost you any money to add payable on death designations to your bank accounts. At least it hasn't at the banks I've used. You can get a will on LegalZoom, but I typically charge $250 for a will. You can get an advanced healthcare directive. I will typically charge same thing, $250 for that. However, if I bundle things, I give people bulk discounts. It really depends upon how complex your situation is, how many siblings you have, are your parents alive, do you have kids, do you have all sorts of different investment vehicles and different accounts. It really depends upon the complexity of your state. I do have my contact information there. I got an email, phone number, legal address, so you're more than welcome to reach out to me at any time. Okay. Benefits. Okay. Well, living with someone and not married, you just got to be extra careful in terms of what you set up. Typically, if you are married, the state has a much easier system for dealing with things. Okay, if you have a bank account with a payable on designation, is the bank account considered probate property? No. Any account that has a designation, a proper designation. So you'll see that. So typically when I ask my clients to show me just one page of their statement, because a good bank account statement will show you whether there's a payable on death designation, or it'll say whether your name as a trustee for a trust, it'll say that on your bank account. So no, any bank account or life insurance policy with a proper designation, beneficiary designation, is not probate property. So that's one way to avoid paying an attorney, is putting your bank accounts in payable on death. But be careful, every time you do that, you set up where that bank account is going to go. Let's say, hey, everything's going great with my live-in girlfriend or boyfriend, and I want to put them on my payable on death designation. And then 2 years later, things aren't good, you're no longer with them, and you forget to take them off a payable on death designation, and you tragically die in a car crash, the money goes to them. As long as your payable on death designation still stands, it'll be recognized by a bank. So if you're going to do things, you want to be vigilant. You want to look at your documents every year on your own. Just make sure that everything is in order. There's nothing wrong with any boyfriend or girlfriend being a life insurance beneficiary. I'm glad you have one. Can you take a legal action against an agent for making decisions that are against your interests? Yes, you can. That the obligation of an agent is called a fiduciary obligation, meaning they are obligated to act within your interests. But there's a gray area when it comes to finances. You may think that your agent may think that your money should be invested in X, and you think it should be invested in Y. And at the time of the decision is made, both decisions are reasonable and could be viewed as in your interests. You don't want a court deciding that. So in that situation, you want your agent to make decisions only if you're incapacitated. But yes, you can take legal action against any agent that violates their duty. It's called the fiduciary duty of loyalty. If they violate that duty, you can sue your agent. You don't want to. That's why you want to be able to trust. Do cars go through probate? Yes, unless they're titled properly. However, typically cars, a lot of people, sometimes that's their only, that they have bank accounts and cars are part of a small estate. So as long as you're under the 184,500, your cars don't go through probate. Cars can be a hindrance and an annoyance to title them properly, because typically the mortgage company holds the title to the, I mean, the loan company holds the title to the car. And until that loan's paid off, they may not allow you to retitle it in, they maybe allow you to retitle your loan, but they may not allow you to retitle the deed to the car until the loan's paid off. So that would be a situation where you'd want to get your loan retitled. And then once the loan is paid off, then the car company will retitle the deed in your trust or however. That's a little bit complicated for cars, but yes, they do go through probate unless they are properly titled in a trust. How are we doing on time?
Yeah, keep going. Good. Another 15 minutes.
Oh, wow, I went way longer than I thought I'd go. I thought I had a half hour of stuff. I hope this wasn't too boring. There's a lot of stuff in here, so I'd be glad to talk to you about. Oh, I'm glad you appreciate it. I did try to keep it as short as I could. I think there's way too many words on my PowerPoint. I like more pictures. I like talking about this stuff more than I like showing a bunch of words. Words make people's eyes glaze over. So take a look at them at your leisure. If there's any questions you have my contact and email information. If you want to run it through Eric first. Oh, awesome. I think this is the nicest class I've had so far.
Boy,
Or
slagging off my other classes.
well, no, I'm just saying I'm getting a bunch of thank yous. Like most of the other classes. So here's the thing. I know now everybody's used to using Zoom, but I think when I first did this on Zoom, like everybody was like, I'm not sure how to use this. I'm not sure I want to go into chat. So I think people just didn't talk. I think people just didn't interact. And I think people now are getting more used to it. I personally hate Zoom. I prefer, next time I do this, I'll make sure I'm available early enough in the day to come to one of his in-person classes. But I'm glad I could do this. And don't worry about being late. Everybody gets a copy of this PowerPoint. You'd rather do Teams. I know people who use Teams. I work with Teams with the city of Coronado. I don't like any video. I'm just too old, I guess. I don't like any video presentation. I'd much rather deal with people in person. But I'm doing the best I can with what we've got. And I think I've done a decent job, at least on time. And
At least on time.
yeah, at least I didn't keep you too long. I don't see anybody logging off or falling asleep. But
that's because he's looking at his presentation.
I'm only looking at my presentation. Yeah.
We have a bunch of blank
Uh-oh.
rectangles.
Well, so there are, I know, but everybody does that for a reason too. I get that. You don't have to.
No, that's what Jesse looks like. Actually, the duck.
It looks like a duck.
Yeah.
Okay.
All right. So, so first of all, thank you very much.
Oh, you're welcome.
I really appreciate that. Very
Glad
kind.
I could help.
Okay.
Should someone, okay. It depends, one, if you don't have any assets at all, I mean, look, there's a lot of people at your age and at my age who don't have any assets of any significance at all, then you don't have to have a will, because your creditors are not going to force you to go through probate once they find out you don't have any assets. If you do have gross assets, then yeah, I do recommend you have a will.
So what's your professional recommendation? Gross assets greater than
Gross assets greater than, gosh, well, because
so above 180, you
definitely obviously above 180, 184, obviously have a will.
What if you don't like any of your heirs?
Well, then you can always give money to charities or to Eric Senko.
Oh, okay. That's true.
Yeah, there's nothing wrong. I encourage my clients to, as a portion of their trust, to consider putting like a certain fractional percentage to their favorite charity, particularly if they have liquid assets. You typically don't want to have your clients try to divide up a house with a portion to go to a charity, because then they'd have to sell the house. You want to have enough money to cover any donation to a charity separate from the house, unless they're planning on selling the house.
Let me ask you a question that
Sure.
might apply to some of our students. I'm an only child, so this doesn't apply to me. But if you have a client come to you and they're older, 70s, 80s, something like that,
I'm definitely going to answer Brian's question,
Okay.
but go ahead.
and they have their main asset is one house,
Mhm.
and they have multiple children, what is your advice in that scenario? Do you help them? Because let's say the house is worth $1 million.
Mhm.
There are 4 kids.
Mhm.
What do you tell them?
Oh,
What advice do
okay.
you give them?
So the basic advice is still do a revocable trust. But tell them, look, if that's your only asset, then the likelihood, unless they can agree, unless the kids can agree themselves as to how it will be distributed, the likelihood is that house is going to get sold in California. Now, you still want to
Because of
avoid
the tax.
because of that Prop 19.
Mhm.
You still want to have a trust because it prevents probate. It prevents probate costs. It prevents attorney costs, or at least it limits it it keeps it out of court. And it allows that house to be sold. If it has to be sold, it can be sold faster. Typically, probate lasts anywhere from 6 months to 2 years. So there's a time component in probate in addition to the money component.
What happens to the house in that time?
You just stay, well,
Does it sit empty?
if it sits empty, no, then somebody would try to rent it or do what they could with it. But you typically can't sell it.
But
You'd have to,
if there are 4 of us,
Yep.
the kids, and I want to live in it, and the other ones want to rent it, what
then,
happens?
okay, it depends, then the administrator gets to decide. Whoever's the trustee, whoever you've designated as the trustee has decided. And that's why it's dangerous to have all 4 kids be the trustee.
Mhm.
You don't want that to happen. All right.
So we have this, can you give money to a person entity with discretion that it only be used for a certain purpose?
Okay. It's tough. Typically that's done with youth, people under the age of 18, under the age of 21, under the age of 25. And it's usually you can usually limit those purposes to educational. But if you try to specify certain other purposes for people, especially people above the age of 18, there's a good chance that if they really wanted to fight it in court, they'd overturn it, because typically you can't restrict people on their disposition of assets that are properly theirs. It's typically more in the situation of minors and dealing with taking care of their life expenses. How long would an agent of property live in the house? If you're talking about avoiding the Prop 19 situation, that person has to live in the house. It has to be their primary residence.
But it gets reset after 1 year anyway.
No, they have to make that decision within 1 year.
Oh, whether they're going to
Live there and maintain the parent-child exception.
Oh, so they can keep that ad infinitum.
They can, as long as they live in the house as their primary residence. They could, let's say they already have a different residence. They could turn the other residence into a rental property. But that property could not be a rental property unless you want to accept the increased property tax. Prop 19. Okay. Right now, Prop 19 is, yeah, that's good. Yes, Prop 19 is California only. Okay, so California rules. So a California trust does not apply to property in other states. Okay, you can list other property in other states in a California trust, but property in other states is governed by the laws of the state in which that property is located. So you may have to have a trust in that state, or you may have to form an LLC or something else that manages that property. That depends upon each state.
So along the lines of what Keisha's asking, I'll let Rob read it here.
Okay.
But I have a friend it actually is a friend, and her father passed away, owned part of a building, and now it's this whole mess where they're trying to, what they had set up was the kids each had their own apartment subject to rent control. The idea being that if something happens to dad or whatever, they will have these apartments under rent control. and the dad passed away unexpectedly. And now they're fighting all this stuff because someone who owns the other part of the building is trying to raise the rent back to market rate. And it's a whole, basically.
Okay, so let's
complete
scroll back,
shit show.
let's scroll back to her. I'm gonna read this because it's scrolled away.
Okay.
Okay. My
So-
boyfriend has a few homes and his brother is on the bank accounts. The boyfriend told me that I could live in one of the homes. He has one son and a grandson. How can I be protected by the information he is telling me? You are not protected by the information he is telling you. You would be protected by a will or a trust that stipulates that you can live in one of those homes and designates that home. Provided it would probably also have stipulations regarding payment of rent or whatever the situation is.
So what
You're-
would you do in that situation with Keisha? Would you say,
I tell the boyfriend, first of all, to marry her. I'm just kidding. I don't know your situation. That's rude. That's rude. Okay.
joking?
It's
he's joking.
no, it usually is easier to deal with spouses than it is boyfriend, girlfriend. That's
So-
just generally.
So Rob just said it's usually easier to deal with spouses. He's obviously never been married.
I am not. But anyway, you would want him to actually have a trust for these homes and you to be a beneficiary of at least a life beneficiary of one of them.
Could you define life benefit?
Life beneficiary means your ability to live in the house while you're alive.
So let's say her boyfriend owns 10 homes.
Yes.
And could he put a home? Could he have a trust for each home? And then
No,
have,
you'd
like,
want it-
one trust for Keisha's home and say that she's the beneficiary of that trust?
You could, but that each time you do, yeah, you're just racking up attorney's fees there if you do 10 trusts.
Well, no, but I mean, something like this would protect Keisha.
Well,
right?
she
And
could
then
also be
she's
protected
totally
by one
separate.
trust that makes designations for each home.
Okay.
And the property funds the trust, redoes the deeds, all of that, all of the stuff that you would need to do. Because otherwise, if he doesn't have, I don't even know if your boyfriend has a will. If he doesn't, then what's going to happen right now, based on just on the information you told me, is that everything would go to his son. Just on the information you told me. Okay.
Oh, dear Lord.
Okay, that's super important. Okay, so you do not need consideration is not required for a trust. Okay, it's not like a contract that requires consideration. That's a good question though, George. Okay, that's good too. This is very important.
I think Keisha needs to reach out to you directly.
Yeah, I think so.
You should probably, I'll shoot you an email, Keisha, with Rob's stuff. These are great questions.
They are, but I think, yeah, so let me tell you though, if somebody is sick, or like I gave the example of Alzheimer's, or let's say late stage dementia. If they're in that situation, you're already running into a potential challenge because when people are in end of life situations, it's more likely that somebody can claim that they are under undue influence or coercion. So that's why you want to head these things off. I'm not saying that it applies in your situation. I'm just, people are certainly capable of making decisions with various stages of life. So I'm not making a specific thing, but I think I do need to talk to you directly.
Could he sell her the home? She owes him the money on the mortgage, and then as part of the will, that's forgiven?
I don't know that. That's a complex question I'd have to research, but that's going to trigger an increase in the property tax base because it's not a sibling or a. You'd rather say it.
Do we miss any?
Somebody has a question. They'd rather say it.
I
Don't want to type it. I'd rather say it.
Oh, okay, go ahead.
Hold on, we'll get you.
Yeah, go ahead.
Professor Eric, you remember when I told you about the situation with my family and with my uncle and my grandfather? Is this the person I talked to and asked him the question?
I can't remember the situation off the top of my head, but yes, I remember you bringing something up, and this is probably a question for Rob, but I can't remember.
Okay. My grandfather and my grandmother owned our house, And then one of my uncle or auntie had a friend, and my grandfather bought that friend a car. She never paid any payments on the car, so my grandfather had to put the house on the line for like a payment. And my grandfather had all his children as if he passed, they would inherit the house. So when that situation happened, he gave my Uncle Ronnie the house as the head of the house. So my question is, if when my grandfather put all his children as the head of the house, can he switch it and just put one person as the head of the house as for all his children in
He
that
could.
situation that happened?
I don't know enough about the specific situation. Like you say he put somebody as a head of household, but I haven't seen any like documents. Like, did he write his will that way? Did he write a trust that way?
The
You can't
situation,
disinherit people. Or did you just say it?
the situation is we're living under my mom's brother, which he said that my grandfather put him on the head of the house, but my grandfather said that he put all his children of
Okay.
the head of the house. So
Okay,
I
so
don't know how we can go about that to
how
know
to
that.
go about finding that?
Yes.
Okay, so I will give Eric some more. It's a little complicated. You're going to need to find the deeds to the property, but I will let's make a note about that. We'll get you a direct response as to what steps you need to take. It's a little bit complicated.
Okay.
Okay, to find out, because I just don't know enough about your situation specifically. That there's a lot of things I'm going to have to get answers to, and then I can give you some steps. All right.
Okay.
Holly has a question. I'm sorry, did you mention transfer on death deed? There is no transfer on death deed. I was talking about transfer on death designations for bank accounts. Deeds to property, once somebody passes away, typically in the county, you file, there's various affidavits. It depends upon what county you're in. There is you provide a copy of the death certificate, and then you file an affidavit, and then you retitle the property. So that's typically the process, but it varies from county to county as to what forms you use, but that's generally the process. If you're talking about something that happens, let's say your mom and dad are on the house, mom passes away, dad is the only one on the deed now because you've submitted the affidavit of death to the county, and then the deed gets retitled. Now that's assuming there's no trust, because if there is a trust, then the trust survives as long as both people are part of the trust. You wouldn't have to do a designation, except if both spouses were trustees, then you still may have to do the affidavit, and it will change the trustee, which will change the deed marginally. So that's a long answer, but it depends upon what county you're in, what forms you have to fill if there's a deed after death. Okay. All right. I think we've got, he never wants to sell his house. Okay.
You can reach out to her.
Yeah, well, I'll reach out. I'll reach out to you, Keisha.
Anyone else want me to send an email?
Well, you're gonna get-
I'll send it. You'll have his contact info, but if you
Yeah.
want, I'll send a specific email and CC Rob on it.
Yep. Yeah. I would appreciate being CC'd. Yeah, we're taking notes. But yeah, you will have my PowerPoint. It has my contact information on the last slide.
Yes, Holly, I'm going to post this. You guys have to subscribe to my YouTube channel. What other questions do you guys have before we wrap up?
If you think of something later, feel free to send it along to Eric. I will answer all questions that I can.
Was this useful to you guys?
It looks like it was useful to almost everybody who responded, which is a shocker for me. I appreciate it.
And you know, I think I've mentioned to a few of you, my grandmother died last year. She had 7 kids, and she had a will, but she didn't have a trust. And she had ideas on what she wanted to happen, and it was a complete shit show. And basically now of the 7 kids, most of them don't talk to each other. There's like, 2 or 3 of the kids that no one else will talk to. And it was an absolute mess. And my grandmother was probably worth $200,000. So, divided among 7 kids, that's not a whole lot. But, given I think of these families who are worth, millions and millions and millions, and like that's real money you're arguing over. But the difference here is like whether you get 27 grand or 32 grand. And now
Yep,
people don't talk.
that's
to each other
exactly
over
why we
that.
do this. It has in addition to saving money, it has the added benefit of keeping families from fighting with each other as best you can.
Cool. All right. Anything else before we go?
All right, thanks, everybody.
Good stuff. Thank you, Rob. Really appreciate it. And I will post this on my YouTube channel and then post the link. And thank you, everyone, very much. I hope this was useful and have a good weekend. I'll talk to you guys
Good
all
night.
next week.